I have a copy of a subpoena that was entered last night compelling Mr. Tremaine.
Look at his face.
To give testimony.
Oh, he's like, oh shit.
He takes a stand and he asserts some sort of privilege to that.
Let's rewind that real quick.
Oh,
It's like, oh shit.
in fucking HD.
Your Honor, I have a copy of a
Wow.
subpoena that was entered last night compelling Mr. Tremaine to give testimony.
That is a scared man.
He is a compulsion adversary.
He's like, what the fuck?
I'm not here. I'm not here.
That's
Wow. Wow.
I don't know what the look was, but it looked pretty guilty to me.
That's some shady shit.
Wasn't me.
That was panic there. That was outright panic.
Honey,
Yeah.
I could explain.
Yeah, I don't. Sorry, go ahead.
There's nothing about this up on the Fairfax County website yet, which I guess is not a surprise because I'm sure they are overwhelmed with getting all the trial stuff processed. But we have seen repeatedly throughout this case the process they have to go through to get a foreign deposition issued. Morgan Tremaine is not a resident of Virginia. He is a resident of California. So if you were even going to try to subpoena him, there's a whole series of steps you have to take that gets filed and so forth. And that process is only available for discovery anyway. So it's just not a good explanation.
Well, so Andrea, do you think that was a holy crap, I got caught doing some shady stuff? Or was that a, what are you talking about? We haven't finished the service yet.
Well,
or both.
I suppose it could be. I mean, yeah, I suppose it could be we haven't finished service yet, but clearly providing it to him and then, like Nick is saying, him relying on this, making this argument to suggest he's under compulsion. If he hasn't been served yet, no, he's not under compulsion anyway, even if this is a valid subpoena. So I think the concern is over the fact that the circumstances are being represented in a way that is probably not 100% accurate.
Yeah, and it looks shifty. It looks very shifty that Ben, like, because the other scenario, the converse scenario would be that Johnny Depp's team, who just represented to the judge that this guy has not been subpoenaed to the court, was actually subpoenaed by Johnny Depp's team. There are only two parties in this case that could issue a subpoena to this guy, Johnny Depp and Amber Heard. So either Ben Chu stood up and lied directly to the judge under in court, in open court, while I guess live, right, in live open court, or Amber Heard's team issued the subpoena, and the subpoena would be actually a big problem for their argument to try and exclude him as well. That's going to be a weird.
A little
issue.
bit, yeah.
I mean, but Elaine already looks ridiculous, so she got blown the fuck out right there when she tried to stand up. So I mean, she's already at this point in for a dime, in for a dozen. Yeah,
so that it's not looking good for Amber Heard's team. This judge wants to hear the evidence. It became so real quickly, for the chat. So an intervener action is what they tried to do. An intervener action is where you have a lawsuit, and typically where you'll see this, you have lawsuits that are crafted to get a result. So you'll have two parties favorable to the same side of an issue, and maybe they want to get like abortion before the Supreme Court. So they'll have two parties that are on the same side of the issue. One will file a lawsuit against the other. And so the question would be, is the defendant in that case, who is on the same side as the plaintiff on the morality of an issue, for example, going to assert a proper defense or a proper set of privileges and immunities to various issues in the case? Or are they going to effectively softball the issue, lose the case intentionally for the purposes of generating an appeal? So then an intervener can come in and say, actually, we're a proper party to assert a right in this case. Here are the reasons why this party is not proper. We need to intervene in the action, and we will take over the defense to make it a legitimate adversarial action. There's a general standing requirement in the law that actions be adversarial. This is actually laid out pretty clearly in the federal standing stuff, but in state courts, it's the same thing. You need to have an adversary to invoke the power of the court, because otherwise it's just a circle jerk that is then rubber stamped by the government, and we don't want that. So they've moved to intervene, but to intervene, you have to have a dog in the hunt. And TMZ does, he opened his argument by saying TMZ has no interest in the outcome of this case. Okay, well then you can't intervene. That, and period. Maybe they should have tried an impleader to bring themselves into the case as like a coexisting party, but they do not get to intervene on behalf of one of the things. And I'm not aware of like intervention for a limited purpose either. That's kind of weird. So, but I'm not done extensive intervener research, so there might be something out there. He didn't write it in his brief, which should tell you enough. But yeah, so his whole argument was that TMZ has a right to intervene because it's TMZ's right to the confidentiality of their sources, which is questionable actually, because it's not TMZ or typically a news organization that is the right holder. It's the journalist, because the journalist develops and cultivates their CI, and it's the journalist's reputation on the line when they pierce that confidentiality and leak a source. It's
also the journalist who's going to end up in jail for contempt if the journalist is the one who is called into court and compelled to reveal it.
Right. So the whole idea for the reason we want to protect sources is so that people are candid to journalists and we have an open press. That it touches on First Amendment issues, but I think, as you said, Andrea, it's not like specifically laid out in the Constitution that there's some journalistic privilege on confidentiality of sources. And so,
no, and that's the whole reason these states have adopted these journalist privileges, is because it is not constitutionally protected. And so some states have chosen to step up and voluntarily do that as a matter of statute. But that speaks to the deficit of the constitutional protection, not that it exists.
Right. And so the idea is that journalists should be in some way by state statute protected from being compelled to disclose their sources so they can maintain good sources. But again, that's on the journalist. And if a journalist goes out and burns the sources, TMZ fires them. TMZ doesn't take responsibility of that burning. That's the journalist. And so when they go to the next organization, they try and develop sources for whatever information that the people will know, oh, wait, this guy burned sources. But I know we have a limited time on this, but James from court, welcome.